Welcome back to the High Court Report, your one-stop shop for Supreme Court coverage.
Today we break down Abouammo versus United States, decided June 11th, 2026. 9-0. Justice Kagan wrote the unanimous opinion. SCOTUS held that if federal prosecutors charge you with document falsification under 18 U.S.C. Section 1519, your trial must take place where you created the fake document, not where the FBI worked. The court reversed the Ninth Circuit. No concurrences, no dissents, 9 justices, 1 opinion.
That's a hard ceiling on prosecutorial venue shopping. And as you may recall from our preview episode before the March 30th oral argument, we flagged this one as a simple story sitting on top of a deep constitutional question. Today, we deliver the court's answer.
Before going further, here's your reminder to follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Just search the High Court Report. And if you have questions about this case, reach out via LinkedIn or email at scotus.cases.pod@gmail.com. All right, here's what you need to know.
Ahmad Abouammo worked at Twitter's San Francisco office. While employed there, he secretly identified 2 Saudi dissidents posting on the platform and handed that information to a high-ranking Saudi official. The official wired him $300,000 in return. That's not a consulting fee. That's a payment for betraying people Twitter trusted him to protect. Then he left Twitter and relocated to Seattle to launch a consulting company.
New city, new chapter.
Except 2 FBI agents from San Francisco investigating those unauthorized Twitter disclosures flew to Seattle and knocked on Abouammo's door. They sat with him for hours. Abouammo denied everything. The $300,000? Consulting fees? Very legitimate.
The agent said, "Prove it." Abouammo offered to retrieve an invoice from his computer upstairs. The agents waited in his living room. While they waited, Abouammo went upstairs, fabricated a backdated invoice on his computer, and emailed it directly to one of the agents. Right then, while they sat downstairs.
He built the fake in real time with federal agents on his couch.
When the agents got back to San Francisco, they pulled up the document and checked its date and time metadata, the digital timestamp every computer-generated file carries. The file's own creation record showed Abouammo made it during the interview itself.
He never stood a chance once they checked that timestamp.
Prosecutors charged him in the Northern District of California, San Francisco's federal district, under Section 1519. That statute makes it a crime to knowingly falsify a document with the intent to obstruct a federal investigation. 20-year maximum.
But Abouammo falsified that document in Seattle, not California.
His lawyers moved immediately to dismiss. They argued the only proper venue sat in the Western District of Washington, Seattle's district, where Abouammo actually created the fake. The district court denied it. Found venue proper in California because the FBI investigation operated there. Jury convicted. The Ninth Circuit affirmed on the same theory. Section 1519's intent requirement, falsifying with the intent to obstruct, made the investigation's location part of the crime's essential conduct.
The Supreme Court granted cert in 2025, heard argument March 30th, 2026, and on June 11th, reversed.
Unanimously.
So, break down the legal question.
Here it is. Under Section 1519, where must the government bring the case? Only where the defendant physically falsified the document, or also in any district where the targeted investigation operated? In other words, can prosecutors put you on trial hundreds of miles from where you committed the crime because that's where their agent sat?
And the Constitution speaks directly to that.
Twice. Article 3 says trials shall be held in the state where the said crimes shall have been committed. The Sixth Amendment, your jury trial right, guarantees a jury drawn from the state and district where the crime actually occurred. At oral argument, Chief Justice Roberts pressed government lawyer Anthony Yang on the history behind those words. Under your theory, Roberts said, Parliament could have shipped Boston Tea Party participants to England for trial. The crime caused effects in England, right?
Yang couldn't cleanly answer that.
He tried. But Roberts hit the historical nerve. The founders actually wrote into the Constitution. The Declaration of Independence cataloged Parliament's practice of shipping colonists across the ocean to face trial for what it called pretended offenses. That practice, remote prosecution, is exactly what the venue clauses targeted.
So what legal test determines where a crime actually occurred?
The framework comes from United States versus Rodriguez Moreno, a 1999 kidnapping case crossing multiple states. Under that test, A court first identifies the conduct the statute actually prohibits, the specific acts a defendant must perform to violate the law, and then locates where those acts occurred. Multi-district crimes can support multiple venues, but the test locks onto conduct, not intent, not downstream effects.
And Section 1519's only conduct element is falsification.
That's it. Knowingly falsify a document with intent to obstruct. Crime complete. No transmission required. No impact on the investigation required. At oral argument, Justice Thomas asked Abouammo's lawyer Tobias Loss Eaton directly, if Abouammo saved the draft invoice and never emailed it, does the crime still complete?
Loss. Eaton said yes, without hesitation. Save the file with the requisite intent, crime done. Delete it immediately after, crime already done. And Yang conceded the exact same point. He told the court the offense completed the moment Abouammo created the document on his computer, before he even pressed send. Both sides agreed the crime finished in Seattle.
So why did the government argue California worked at all?
Two theories. First, the government called Section 1519 an inchoate offense, meaning a crime that's only a step toward committing another crime. Think conspiracy to commit robbery. The agreement itself is a crime, even before anyone robs anyone. Under inchoate offense law, you can sometimes face trial wherever conduct furthering the crime occurred.
And Yang pushed a vivid analogy for that.
He argued Abouammo shot the email at the Northern District of California, like aiming a gun from Seattle at a target in San Francisco and pulling the trigger. The bullet lands in California. California counts. And he analogized the emailed invoice to an overt act in a conspiracy, a further step manifesting the intent to obstruct.
But Justice Kagan dismantled that in real time.
She pinned Yang on a critical concession. She asked if Abouammo created the document, harbored full intent to obstruct the California investigation, and just put it in a drawer, never sent it, venue still wouldn't lie in California, right? Yang conceded it. Under the government's own theory, intent alone doesn't deliver California venue. You need conduct actually producing a detrimental effect in the district. Justice Barrett caught that immediately. If the theory requires effects the statute never required, the theory runs outside the statute.
And Justice Gorsuch finished off the conspiracy analogy.
Pointedly, conspiracy works as a continuing collective enterprise. The acts of co-conspirators get imputed across the whole scheme. Section 1519 has no collective, no ongoing enterprise. One person, one act, done. Yang had no good answer to that distinction.
The court also had binding precedent from 1944.
United States versus Johnson. That case involved the old Federal Denture Act, which barred mailing unlicensed dental appliances across state lines. The court held venue sat only where the defendant dropped the package in the mail in Illinois, not where it arrived in Delaware. Crime complete at the Illinois mailbox. The denture traveling onto Delaware carried zero legal weight, and the defendant's purpose of sending it into another state didn't relocate venue to Delaware either.
That's the direct parallel. For the purpose of in Johnson mirrors with the intent in section 1519, almost word for word. Same logic, same result. Abouammo's crime completed in Washington. The trial belonged in Washington, full stop.
All right, what does this actually mean?
For anyone charged under section 1519 going forward, trial must occur in the district where the falsification physically happened. FBI investigation in Chicago, falsification in Phoenix, trial goes to Phoenix. The government can't transplant the case to the investigation's home court.
And for a real defendant, that distinction changes everything. Remote trial means leaving your community, your witnesses, your support behind, to face strangers in a city with no connection to what you actually did. The founders wrote the venue protection for exactly that reason.
For prosecutors, this restricts flexibility across every multi-district obstruction matter. Federal agents based in Washington, D.C. routinely investigate conduct that happened in Texas, California, Florida. Under today's ruling, Section 1519 charges follow the defendant's conduct, not the investigation's address.
The court also left neighboring statutes untouched. Other obstruction laws, like Section 1512, carry their own Congress-written venue provisions. Today's ruling doesn't touch those. Future cases will decide them separately.
Justice Barrett also raised a practical wrinkle at argument. She asked whether the statute of limitations on this specific charge against Abouammo even expired. Yang didn't know. He did note that Abouammo already served all 42 months of his sentence across all 6 convictions, which makes retrial on this count practically complicated.
Bottom line,
the Constitution requires trial where the crime occurred. Section 1519 defines the crime as falsification. Falsification happened in Seattle. 9 justices agreed. The venue right doesn't ask whether the defendant deserves it. It just asks where you did it. Thanks for listening to today's High Court Report episode. Remember, please follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Follow on LinkedIn for written rundowns. Just search the High Court Report. And if you have questions about this case, reach out via LinkedIn or email at scotus.cases.pod@gmail.com.
and if you ever find yourself upstairs fabricating a document while FBI agents wait downstairs, might want to subscribe before you send.
Truly, metadata never forgets. Talk to you soon.